He recently lost his stepfather. His mother requires his help. He does have a severe stuttering disability. Would you like to tell the court about your father, grandfather, and that you need to be home with your mom?
Case is over a year old. The motion for continuance is denied. Court is going to sentence you to 8 years in the prison.
Judge, did you say 8 or 18?
18.
One person, one other time in front of me, and that was for dues. So don't tell me you've never had to do it this way.
Okay, $350.
All right.
I don't have an answer for that.
Yes, ma'am. Do you know why you don't have an answer to that?
Because I wasn't told I had to do that.
Since the end of April of last year, I've been disabled. I've had a serious fall and fractured my spine. It was
New at 6, she was a little girl with $1 million smile. But 3-year-old Ronnie Salazar spent her last days fighting to survive. Investigators say Ronnie lingered near death for almost 1 month, and now a woman is in jail charged in connection with her death. KENS 5 reporter Sue Kalberg has the details, which are difficult to hear.
Detectives looking into what happened to the girl found enough evidence to charge her guardian, 49-year-old Yvonne Perez. Her bond is $200,000. The mom says this was not a court-ordered placement, that she needed help with her kids, and Perez offered to care for Ronnie and her brother while the mom recovered from hard times. After Ronnie was hospitalized, her brother was found unharmed. He has been placed in a safety plan, but Ronnie's funeral services are pending. Now, police say it will be up to the district attorney about whether or not to upgrade the charge, but the medical examiner hasn't even made a final ruling on the cause and manner of death, so the investigation continues. And meanwhile, at KENS5.com, you'll find a link to the family's effort to raise money to bury the little girl.
My wife got the privilege
I think she may need a chair.
of driving home.
All right. So you drove?
We drove. I only could drive 2 hours on the way back. It's not in any shape.
So how were the children?
The kids were better than me.
Yeah. All right. So an offer has been tendered. Is she accepting the offer, or this scheduled for jury trial?
Scheduled for jury trial.
All right.
Also, Judge, we have an expert. He noticed that we were missing some things from university. I don't think it's gonna really change anything from the perspective of the state. So we would still ask for a trial date, but I just wanted to make the court aware of that.
All right. So Ms. Perez, after today, the court is, you can remain seated. After today, the court is not accepting any plea bargain agreements in this case. Yes. So after today, if you're not accepting the offer that's been tendered or no agreement is happening today, then the court will not accept any plea bargain agreements without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes, Your Honor.
All right. So how long are you all expecting this trial?
I would say a week. It could go to 2 weeks.
Are there 13-hour videos?
No, just a lot of expert witness.
This will be probably 4 days then. And what we'll do is, for this one, we may end up doing jury selection on Monday, which you'll see. Ms. Ferguson, I need a jury trial date for this. And could you put this sort of quick, fast, in a hurry? Court is calling 2022 CR 11873, State of Texas versus Yvonne Monica Perez. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Matthew Allen.
Are you Ms. Perez?
Yes, Your Honor.
All right, you're going to have to speak up. Nobody can hear you.
Yes, Your Honor.
All right. Counsel, was an offer tendered to you
Yes,
by
sir.
the state? And Ms. Perez, are you aware of the state's offer?
Yes, Your Honor.
Are you rejecting that offer?
Yes, Your Honor.
All right, Ms. Ferguson, what's the jury trial date? No, for the judicial conference. But yeah, Can we put it for the 18th? I know what our rules are.
Of September?
Yes. Will you?
Okay, Judge.
I'll be not in the state on 18th.
Oh, where will you be?
Anaheim. It's the first time.
Oh, well, you got to spend time with your son. Can we put it for the 25th of September then? And then what we'll do is your other date, we'll do something else.
I will be here.
Is the 25th? September 25th? What are they trying in on September 25th?
That's after gonna run into, Ricky's,
October 3rd, we have another case with very similar, another dead child case at October 3rd.
What if we were to put it on August 21st or 28th?
28th, I have, criminal trial division on murder.
All right, 21st.
Georgia, I'm not,
Oh, you gotta be gone.
no, I'll be here, but I'm expecting to be in trial on the 186. It's well, now it's a sexual assault of a child. The case is about 4 years old.
Oh, we'll see what happens. Maybe they'll drop theirs, right?
Judge, on the 21st, Brittany's in trial with,
That's when we did the impact case with Lee Cutter for Manny Rodriguez.
Okay. August 7th.
August 7th.
Mm-hmm.
I don't have anything, but
I guess my concern would be with, I don't know if we're gonna have the records back for his expert in time for his, I don't know if his expert would even.
I have Mary Diaz. I have several others.
ambitious.
But see, here's the thing. We keep setting these cases and stuff doesn't go. So let's just pick a date and we'll see what goes. Either it won't go or either something will be in front of it or it won't.
If we could lock in the November date. I'm not trying to push cases out. I try.
Oh, I
to work
understand.
cases.
Oh, no, I know you try a lot of cases and I know in here people try a lot of cases because we're in trial every week, but she's in custody and I want this case tried. So, Ms. Ferguson,
Yes, ma'am.
give me a date. That's not in November. October, the latest. And are you Yvonne Pettis?
Yes, ma'am.
All right, this case is set for jury trial. The defense has filed a motion for continuance. And state, according to their motion for continuance, they're saying because their expert is not available.
So last time, just to expand on that, we got discovery, some of this stuff basically has to be put on a drive and mailed. So I mailed it, expert didn't get it, so I had to remail it. So I haven't had an opportunity, the expert's not available, plus I haven't had an opportunity to review it with him, conferred with the state. I believe they're unopposed there.
We are unopposed due to the voluminous nature of the discovery.
All right, so as both parties know, I don't like cases to be sitting around. In this case, will have been sitting around for a year. And when I say sitting around, I mean January 13th. Case was indicted and there was no autopsy available, which I don't understand why case is indicted. And I know it wasn't you.
Mhm.
I don't understand why case is indicted and it's a murder case and there's no autopsy, but that's neither here nor there. And then finally on May 25th, the autopsy was completed and everybody needed to review it in order to make an offer. And then June 8th, this court was in jury trial, so we can take up this for trial. And then June 12th, defense attorney was in a federal trial. And then July 10th, that was when an offer was tendered and a plea deadline date was given. And then July 24th, there's an issue with counsel illness. And then on July 31st, the offer was rejected and it was set for jury trial on October 30th. And that was reset. And I'm assuming it was reset because we were probably in a jury trial.
It was either that, Judge, or we've had a lot of discovery issues with it. There were subpoenas that went out and that they said, well, this isn't the hospital that did that particular part. So they
Mhm.
reissued subpoenas. There was doctors who, for some reason, their records weren't at the hospital, so that individual doctor had to be contacted. And so we should have everything now. I came over like 2 weeks ago and brought a hard drive just to read. So I should have at least duplicate copies of everything, just because I wanted to make sure that there's nothing missing. So.
All right, so you all understand that unless there's a plea that's going to be entered in today, the plea deadline date has expired and the court is not going to accept any pleas without good cause. Otherwise, you have to enter a plea open to the court. Does everybody understand?
Yes, Your Honor.
Yes, Your Honor.
All right. And so my understanding, Ms. Perez, is that you're requesting a jury trial. Is that correct?
Yes.
All right. So how long are you all expecting this trial?
It's probably gonna be what, 2, maybe 3 weeks?
No, I don't think so.
I
mean, there are a lot of-
2 weeks. There's gonna be a ton of medical testimony. It's gonna be the more complicated.
All right.
thing.
Are there any videos?
Ms. Pettis has an interview.
All right. All right. We can go off the record. Now, I always ask about the videos because unless there's a video that is 13 hours,
Oh, yeah.
I don't, yeah. So
Oh, no.
that's how I
Yeah,
judge
no,
it.
no, no.
All right. So is there a video that I need to watch? Is there going to be a motion to suppress or anything of that nature?
There may be a few redactions, but it's nothing. I don't see any suppression issue with the video.
All right. So if there is a suppression issue with the video, we'll carry it with the trial. But if you know you're going to have that, make sure that I have the video beforehand so we can go right into the argument and not keep jurors waiting.
Yes, Your Honor.
All right, Ms. Ferguson, on this case, they're saying it's going to be 2 weeks. I think it'll probably be 5 days testimony. Norma gives me the look.
And Judge, one last thing, we filed a writ for habeas for bond reduction, and I don't know. I don't know if this court hears it or if we'll.
Oh, I will hear it. I don't have the motion though.
I think they had it in the file.
Ah, you know what? I have it. You're right. Are you going to go back on the record? With regards to the motion for continuance, it's unopposed. State, do you have any objection to the form that the motion is in?
No, Your Honor.
All right, then the court will grant your motion for continuance. And what date are we doing this? Counsel is. All right, Ms. Perez, you're going to be brought over dressed for trial in whatever civilian clothing you have at the jail. If you wish to be attired in something differently, you'll need to do a clothing exchange with your attorney. Counsel, if there's an issue with the clothing exchange, just let the court know and we'll see if we can help expedite that.
Judge, that is spring break.
Oh, is that spring break for you?
Yes.
Do you have children? Do you want to be there for spring break?
I can answer the first one affirmatively. Yes, I have two. The second one, it depends.
All right. Ms. Ferguson? He's on spring break.
You want to do that April 9th then?
We can do it April 9th. But if we do this April 9th, I'm assuming this will be completed before. Let's file an application for writ of habeas corpus seeking bail. She has bail. You're seeking a reduction?
Correct.
All right. State, are you prepared to proceed?
Yes, Your Honor. It is the defense's motion, but the state.
No, I mean, if you're just
Yes.
ready to proceed.
Yes, Judge.
All right. So defense, the bond is set at $200,000.
Yes, Your Honor.
You may proceed. Everyone, I need you to whisper. Please whisper.
She's been in continuous custody, so she's unable to make bond. Her family and friends are either unwilling or unable to help with her bond. Her assets, because she's been in custody for so long, she doesn't have any. She doesn't have any money. She doesn't have a house. She doesn't have a vehicle. And in addition to that, we've outlined 2 different incidents that happened at the Bexar County Jail, where she's been attacked 2 different times. And the most recent one led her to be in a wheelchair and the condition that she's in. She does receive medication from the jail, but they've told her that there's no physical treatment available for her at the jail. And so we're asking, in addition to just unable to afford the bond for medical purposes as well, to be able to get out, seek medical treatment. She would have a place to stay here in San Antonio, Texas. She could be on full monitor house, full GPS, because the case involves allegations where someone's under 18. She would be able to stay at a place that has no children and no access to children, if the court, would feel more comfortable with that. So we feel that with those conditions in place, the community would be safe, and she would, with the GPS condition as well, there would be no worry about her appearing for court dates.
All right, state.
Your Honor, as you know, this case involves the death of a child.
All right, everyone, please whisper.
A pretty horrific death of a child. And at this time, they are allegations, but due to the serious nature, we feel that $200,000 is appropriate. But that if the court is willing to lower them, then obviously full conditions. But for something involving something like this, I feel like anything lower than 150 even would be just way too low. It also is a little concerning that no one's willing to help her, because then how is she going to be supported in the community? That's concerning to the state, Your Honor.
Well, just to clear it up, it's not no one, it's just people unfortunately, the people that are willing to help are just unable to do so financially. So.
All right, the court is going to deny the motion, and the court has had no evidence on what amount of bond that she is able to make. So at this time, the court will deny the motion. And counsel, if there's an issue, is your client in protective custody?
Yes, Your Honor, now.
All right, if there's an issue at the jail with her safety, just let the court know. But my understanding, she is in protective custody. Beyond that, that's all I can do. And counsel, I've always found them to be receptive if there's an issue with danger. Okay.
Yes, Your Honor.
All right, thank you.
Thank you.
Thank you, Judge.
Okay, I see her off to the
Okay.
side. She can stay there.
Okay. Oh, yeah.
She can stay there. That's fine. All right. So we're scheduled for jury trial today. In this case, the defense has filed a motion for continuance. The court has reviewed defense's motion for continuance. Defense's motion for continuance is denied. Is there anything else?
I guess I'd just like to expand on the continuance.
Sure.
One, I'm just not available. I have some childcare issues, so I put a notice with the courts saying, so my wife is out of town, so I have to be home to get my son. He's only 7. Two,
We'll work around that.
okay. Two, we did just receive a new offer today. I've spoken briefly with Ms. Perez about it. I'd like a little bit of more time to go over the offer with her. And then 3, our expert is not here, he's from out of state.
All right, you all have till 11:30 because that's when the jury is coming up. Previously, there was an agreed motion for continuance back in December 4th, 2023. This case has been going on since January of 2023. This case is over a year old. The motion for continuance is denied.
Okay, thank you, Judge.
You're welcome.
Yes, Your Honor.
Anyone want to say why I should follow this plea bargain agreement?
I can speak briefly on that, Your Honor. I think the stipulations, so the way that she came about, Ms. Perez came about to have the child was kind of strange to begin with. She, in my opinion, I think saw these 2 children that were on the streets. Her and her partner tried to help take them in. And then obviously there was an incident that Ms. Perez describes a week prior to this where, again, she should have taken the girl in for medical treatment immediately. And then obviously she fell from the stairs.
Let's backtrack a little
Okay.
bit. Because it says in the stipulations that there were 2 people outside of the store. She says she's being a good Samaritan. So she takes them both back to her apartment. And then she tells one of them, I can no longer keep you here. You need to leave. But I'll keep the complainant.
Yes, her and her partner, so her partner ended up, I believe, keeping the younger boy, and she kept the younger girl at the apartment. And then,
And is this younger boy currently alive?
Yes,
Yeah.
Your Honor.
yes,
And where is he?
As CPS has removed him, I believe he's with other families.
Okay.
the incident described that is the leads to this tragedy, obviously, is Yvonne describes it as she's playing. Obviously, the kid shouldn't be playing on the stairs. We know that. She hits her head and her back. She seems like she's okay as far as checking on her. She's eating, watching
So why was
TV.
she pinching her as a sign of as punishment? Because that's what it says in the steps, that she would pinch her.
Yes, sir. I
Why?
It wasn't like I'm pitching her, just kind of like a grab, like just
It says it
to
left
prompt her.
bruises.
Huh? I'm sorry.
It said it left bruises.
I didn't realize it was gonna leave a bruise. I didn't intentionally do it to like leave that bruise. The little girl, when my daughter was, when
And so I think she's describing as, yes, she again is admitting to that. It doesn't matter whether you think it's gonna leave a bruise or not leave a bruise. I think we would agree. And then as far as her actions, she seemed like she was okay. And then the next morning, obviously she's not, and then drops her off at the hospital, and then obviously does another bad thing, just leaves her and then leaves. She does come back. She does sit down with the police. She does talk to them, tell them everything that's going on and what happened. Obviously, at that point, it's too late. But I can speak to Ms. Perez from the day I've been with her for 20 months or so, from the day I've met her until today. Every time I talk to her, she's upset. And it's not because of so much of her situation, it's because of what happened. And she knows that she did wrong. She knows she wishes she could go back in time and change all of that. And she says that every time I talk to her. And so
Like maybe if somebody is offering you a child, maybe calling the police.
yes, going that far back. It's not one mistake. It's things that happen over and over. And again,
So was the child healthy when she received the child?
I
Was the child healthy when you received the child?
the first one is Joel.
No, I'm talking about the child that is deceased.
I don't
Was that child healthy when you received the child?
healthy in a sense. I mean, she was
Healthy in the
skinny.
sense that
She
she
was
had-
skinny.
Did
We
she have
fed
all her
her.
hair?
Did she have all her what? Her hair?
On her head?
Yes, Your Honor. I mean, only like patches, like not patches, but like her hair was thin. Her hair wasn't thick. It was thin. Her hair was thin. And she came when I picked her up when Cassandra told me to go, and when we went to go pick her up, she had like a dirty little outfit. I bought her clothes. I mean, there's a lot of things that I should have done and I didn't do when she first arrived at our home. I should have taken her to get a welfare check. I should have done, and I didn't. I just was
Well,
trying to
and like Your Honor said,
help.
I mean, the initial thing would be to contact authorities to go through the proper channels. I think CPS was contacted prior to
They did.
this and made contact with Ms. Pettis, so they were aware of the situation, but again,
Aware of what situation?
that the girl was staying with Ms. Pettis. But
Was
again,
that before or after the child
before,
was taken to the hospital?
before, I believe.
So Child Protective Services was aware that somebody off the street gave her a child. And she picked up the phone and called Child Protective Services and said,
No,
"I have this child."
No, Ms. Pettis didn't. They contacted her. So again, I agree with the court. She should have done a lot of different things.
Well, I mean, I'm just unpacking things a little bit.
Yes.
So,
The mother has extensive history with CPS and had different children taken away, so I think CPS was checking into the whereabouts of Ronnie and Howell.
all right.
Was told that.
So that's how CPS found out that the child was in her care,
Yes.
and CPS did nothing.
Parent.
Okay. I mean, CPS workers sometimes, well, many CPS workers are overworked and underpaid, but I'm wondering why would a CPS worker, and this is just a side note, why a CPS worker would leave a child with somebody that a mother just gave to that's a complete stranger. I guess that's something else that needs to be addressed.
Yes, and like I said, the circumstance behind it are, just to put it, I guess, strange, and that's one of the things that I found strange as well, to, I guess, put it nicely, but.
So why am I following this plea?
Your Honor, at this point, the state, after much back and forth, we recommended this plea due to what is actually being charged, and what we can prove. It becomes a question of whether or not we can prove that she did not seek adequate medical attention in terms of she has training as an LVN and attempted to keep an eye on the child at home, and it becomes whether or not we would be able to prove that she failed to do so due to how it is charged, Your Honor. And so at this point, we do feel 18 years for what she is charged with is appropriate.
All right. And does she have a license as an LVN? I'm assuming
She did in the past.
She did in the past, and then I needed to renew it.
It's
'cause I went-
expired, is that right?
Yes, and
Yes.
then I started going to school to EC. Oh, sorry.
That's okay. It's expired.
All right, this is what the court is going to do. As previously stated, the court is finding you guilty. Court is going to sentence you to 8 years in the prison, give you credit for any time served. There's to be no contact with minors. There's to be,
Judge, did you say 8 or 18?
18.
Okay.
Yeah.
Just make sure.
Did I say 18?
Okay.
All right, thank you.
It's okay. Matt and I are done this
Yes, all right.
morning.
18. All right, 18 years in the prison, credit for any time served. There's to be no contact with minors, and there's to be no employment in the future with minors or vulnerable persons. Is there anything else with regards to sentencing?
Not sentencing, we do have victim impact, Your Honor. One.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargaining agreement? Because I followed your plea bargaining agreement? And because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing, whether you had your LVN license or not, I saw where you took your dog to the groomers. When a child is sick, you take a child to the doctor.
Yes, Your Honor.
I don't know why. Sometimes people have more love for their animals than they have for little children. Good luck to you.
Thank you.
Yes, Your Honor.
And you say there's a. Do you understand you're charged with the offense of aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding you guilty if you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, he's got a very limited history. He's got very limited education. He understands the position he put himself in. He's sorry for that. I believe that court may consider looking at some mental health possible treatment in the future. And limiting his community service because of his age and circumstances. We'd ask that the court consider less than 8 years as far as for the recommendation for the length of time for probation.
All right. Do you have any children?
No, ma'am.
How old are you?
21.
I'm sorry, what?
He's got a stutter, Your Honor.
Oh, no problem.
Thank you, sir.
Just take your time.
I'm 21 years old.
All right. So who is this Renee person?
She was an ex-girlfriend.
So she's somebody's girlfriend?
No, she was my girlfriend.
All right, the way the Renee is spelled, it's not spelled as though it's a girlfriend's name. Maybe they spelled it wrong in the report, because I'm reading in the police report that Renee was trying to goad you into fighting with this person.
That is not true.
So are you and Renee still together?
No,
So where are your parents?
they're in the bag.
So where are you gonna live if you're placed on probation?
With my stepfather and mother.
Does your stepfather and mother want you there?
Yes, ma'am.
Have they told you they want you there?
Yes.
Defense, do they want him there?
Yes, Your Honor.
How far did you go in school?
Just 8th grade.
Why? Why didn't you complete everything?
Because I chose to hang with the dark crowd. And but I'm willing to take my GED classes out there.
All right, because it's like, what do you expect you're able to do with an 8th grade education? There really isn't much you can do. And it's not upward mobile for you if you only have 8th grade education. So you're going to have to figure out what you want to do with your life. And part of that is going to be getting your education. All right.
Yes, Your Honor.
Now, have you ever been diagnosed with any mental health issues?
Not that I know of.
Do you know, counsel?
I have not been made aware that he's been diagnosed, Your Honor. Just in speaking with him, I believe it's regarding anxiety and things like that. I think would be helpful to him.
All right. Any other questions?
No, Judge.
No, Your Honor.
All right. So his mom is here.
Yes, Your Honor.
All right. Mom, could you come up, please?
She is a. Does she speak?
No, that's fine. All right. Could you let her know she can have a seat then?
Yes, Your Honor. It's in the process.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give be the truth and nothing but the truth, so help you God?
I do.
All right. You can lower your hand. State your name for the record.
Luis Bautista Senior.
Okay. And have you always been in Victor's life?
Yes, since he was 10 years old.
Okay. So if I release him today, will he be allowed to live at the home?
Yes, he does. He's got a room.
He has a room?
Everything.
Does he have ground rules there?
Yes.
And what are the ground rules?
No smoking inside the house. Make sure he's home early.
All right.
Try to find him work with me. I do construction work.
Okay. So you think you'll be able to find work for him?
I'm pretty sure I will.
All right. So what time do you want him at home?
Before
What
dark.
hours?
Before dark.
Okay. Are you going to be able to do that if I allow you to live there?
Yes, Your Honor.
Okay. So we're not going to do it live, but I'm going to want you to make sure that you give probation the address where he's going to be living.
Okay.
All right. And for him to be successful on probation, communication is going to be key. So if there are any issues where he's not obeying your rules, let me know so I can see which rules he's not obeying if that's the case.
I think I did pretty good with my other 3 kids who were on the Navy. I only got 1 more in the Navy.
Okay. All right. Is there anything else I should know about Victor?
Well, I mean, besides him being hurt from the back, I mean, he had an accident, sometimes it might keep him from doing some of the stuff, picking up heavy stuff.
All right. What accident did he have?
A bicycle accident with a car.
All right. So has he been evaluated for any mental health issues or anything like that?
No, after he had the accident, he had to learn how to walk again and everything else.
Okay.
And he was in intensive care for about 3-4 months.
Okay.
Trying to get, because they had to put weights in his back and his head to keep it level and everything else.
Okay.
I mean, most of all, he's a pretty good kid.
Okay.
I've been with him and his mom, we've been trying to do the best, and hopefully now he learns and he'll straighten up.
Okay. All right. Thank you so much.
Yes, ma'am. Thank you.
All right. This is what the court is going to do. The court is going to place you on 6 years deferred adjudication. There's a $1,500 fine that will be probated. There's to be no contact and restitution, if any, to Adolph Perales Jr. There's to be no contact with Alvarez.
Yes, ma'am.
All right, there's to be no contact with Renee Alvarez. There's to be regular reporting by Zoom or in person. I'm going to want field visits 2 times per month until further notice. We're going to do a curfew. So you're going to need to be in your house by 7 p.m.
Yes, Your Honor.
The only reason for you to be outside the 7 p.m. window is if you're at work. You understand?
Yes, Your Honor.
So we'll do 7 a.m. to 7 p.m. unless he's at work. There's to be regular UAs. There's going to be 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. It's going to do anger management. And once he completes the anger management, the remaining of the community service hours can be waived.
Yes, Your Honor.
And he's either going to get his GED or get some type of trade certificate. Probation, is there anything else he needs? All right, and I'm sorry, there's an affirmative finding of a deadly weapon. Is there anything else you need from the court in order to be successful?
Your Honor.
I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Good luck to you. The key to having a successful probation in this court is communication. If you have a question over whether or not you're allowed to do something or not do something, you need to call your probation officer, okay?
Yes, Your Honor.
And when you stay at home with your mom and stepfather, make sure that you help around the house,
Yes, Your Honor.
because I'm sure they're going to let you live there for free, okay?
Sure.
All right, good luck to you.
Thank you.
You're welcome. Who's calling 2022 CR 9447, State of Texas versus Victor Manuel Mendoza? Can I have parties announced for the record for the state?
Lindsay Shaw for the state.
Nathan Slemay for Mr. Mendoza.
Are you Mr. Mendoza?
Yes, Your Honor.
Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Victor Manuel Mendoza who was placed on deferred adjudication in 2022 CR 9447 for the offense of aggravated assault with a deadly weapon on December 13th, 2022 for a period of 6 years? Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 1, on or about the 20th day of January 2023 in Bexar County, Texas. The defendant Victor Manuel Mendoza committed the offense of evade arrest or detention in violation of condition number 1.
How do you plead to that? True or not true?
True.
We'll waive all the remaining violations, Judge.
Did you, any objections to the waivers?
No objection, Your Honor.
Did you understand by pleading true to violation condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there an agreement?
Yes, Your Honor. The agreement is that the court deny the MCR to be continued on probation, and we alter and amend conditions for state ISF cognitive track.
All right, is that your agreement?
It is, Your Honor. I guess with the further understanding that the state will be dismissing the evading misdemeanor. I don't have the case number in front of me.
That's correct.
In exchange for his future.
All right, is probation in agreement with this?
That was probation's recommendations, Judge.
All right, the court will deny the motion to alter and amend conditions to include state ISF cognitive. Defendant will remain in custody until transfer.
Thank you, Your Honor.
You're welcome. We can go off the record. Mr. Mendoza, Mr. Mendoza. I don't know what your issues are, but this is something that you need to be thinking about. Every decision you make, you need to ask yourself whether or not this could result in you going to prison for 20 years. Do you understand?
Yes, Your Honor.
All right. All right, probation on Victor Mendoza. He pled true to violation of condition number 1, and the court followed probation's recommendation.
Thank you, Your Honor.
All right, thank you.
Thank you, Judge.
Julio. All right. All right, Mr. Mendoza, did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amended Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney. These two documents.
Yes.
All right, did you understand them?
Not,
All right, let me ask you this. Do you understand that you're on deferred adjudication for aggravated assault with a deadly weapon?
Yes.
Do you understand that the state has filed a motion to revoke stating that you have violated the conditions of your probation?
yes, Your Honor.
And do you understand that in these two documents, the first amended motion to enter adjudication of guilt and revoke community supervision and the motion to enter adjudication and revoke community supervision, the state put in these documents the items that they're saying that you didn't complete or how you violated your probation? Did you understand that?
Yes, Your Honor.
Are you the same Victor Manuel Mendoza who was placed on deferred adjudication in cause number, that's the cause number, 2022 CR 9447 for the offense of aggravated assault with a deadly weapon on December 13th, 2022 for a period of 6 years? Is that you?
Yes, Your Honor.
All right, state.
Violation of condition number 1 on or about the 18th day of January 2025 in Bexar County, Texas. The defendant, Victor Manuel Mendoza, committed the offense of criminal trespass in violation of condition number 1.
How do you plead to that? True or not true?
True.
We waive and abandon the remainder.
Any objections?
No, no, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court is finding violation of condition number 1 true. Is there a proposed agreement?
There is not. State is asking that you revoke defendant community supervision and adjudicate him and sentence him to 6 years in the prison. The reason that we're asking for this is because this is the third MTR that's come before this court. And he has not used any of the tools that probation has given him to redirect his behavior as played by the new offense that he made.
Okay. And defense, what are you requesting?
Yes, Your Honor. And further, the agreement with the state is that you're going to TIC the 3 new misdemeanors.
Yeah.
Okay. There are 3 new misdemeanors, Your Honor. My client does have an explanation for these 3 misdemeanors, but he is pleading true. And as you can see, he has a severe stuttering situation, but he wants to explain, like one of the offenses was a failed ID. And I believe the officer really couldn't understand him when the officer said he wouldn't give his name, but
Okay.
my client would like to explain his situation, but he is accepting responsibility. So would you like to tell the court about your father, grandfather, and that you need to be home with your mom?
Your Honor, my stepdad was in another hospital. Yeah. My stepdad was in another hospital my stepdad was in another hospital. I had lost track. I was taking care of my mom, and my stepfather just passed away, and my stepfather had just passed away just about 2 months ago.
Victor, can you tell the court,
Well, if he's going to give testimony, I'll have him raise his right hand. Or do you want to proffer what he's going to say?
can I proffer what he's going to say?
Yes.
He recently lost his stepfather. His mother requires his help. He does have a severe stuttering disability. He believes that the varied ID was a miscommunication with the officer because the officer didn't think that he was answering his question. And you could see, Your Honor, he has a very difficult time communicating. He had a criminal trespass that's also that he's accepting responsibility for, but he said that that was also a misunderstanding with I guess the store owner. It was a Dollar Tree. As you can see, Your Honor, my client does have a severe stuttering and communication issues. He does understand that this is his third MTR. He does understand that he is going to be looking at revocation. He is simply asking the court to show mercy on him as far as a sentence. I know the state is asking for 6. We are asking for less. And he does have some credit, Your Honor, and I've been checking with probation and with your clerk as to his credit. He has 403 days, and he also did ISF twice, so that's another 183 days. So he should have 586 days total. We are asking this court to show some mercy on him and to sentence him less than the 6 years, giving him all full credit that he has earned.
All right. And state, what cases are you taking in consideration?
That would be 2025 CC 001646 criminal trespass. 2025 CC 005683 evading arrest. And then the 2025 CC 005637 bill time.
All right. So this is what the court understands. The failure to identify. Maybe there were some communication issues, but the evading arrest, there's no communication issues with that. For example, you're able to understand what I'm saying. So the evading arrest has nothing to do with verbal communication. The criminal trespass really has nothing to do with verbal communication. Because when the people at the Dollar Tree tell you to leave and give you a warning not to come back, then you're not to come back. And if you come on their property, then it's a criminal trespass. This is the 3rd time you've been before me. And your attorney has told me that you had some issues going on with your family. I always tell people, all you have to do is let your probation officer know. And if you feel as though they're not responding, you can come back to the court. And I know I would have told you that because this is your 3rd motion to revoke. There's only so much work that I can do to try to help people. And if you don't want the help and you're not going to do right, there's nothing I can do. The court is finding violation of condition number 1 true. The court is going to find you guilty. The court is going to revoke. There's an affirmative finding of deadly weapon. Was there any restitution probation that was ordered? All right. I'm going to give you credit for any time served. I'll give you credit for successful completion of ISF, taking consideration 2025 CC 001646, 2025 CC 005683, 2025 CC 005678, and I'm sentencing you to 6 years in the prison. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it? It's this document that tells you whether or not you have a right to appeal. Did you review it with your attorney? And states you may be excused. All right. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Good luck to you, sir.
Thank you, Anna.
You're welcome. Yes.
Himself muted. I'll handle how the court
Okay.
works, ma'am.
All right.
Don't
that's fine.
address the other parties directly.
Okay. thank
This
you.
is file 25-00309 SC, Candlelight Condominiums versus Tibbetts. Parties are here for a small claims case. What that means is we're trying to get this done without any attorneys. Nobody is represented by a lawyer at this time. We are also trying to get this done without any thing like a jury trial, but for this just to be decided right here in front of me. On behalf of the Condominium Association, Ms. Behrens, what is it you do?
I'm the president.
Okay, I just need to make sure you can answer for that. And so essentially this is, I understand past dues. And then what I don't know about is finance charges. I'm assuming you're charging something for late fees.
Yes.
You're allowed to do that as long as it's
Right.
reasonable. I just don't have that listed. So Mr. Tibbetts, part of you living there is that you have homeowners association dues. All right. And for some reason now they're suing you because they're saying you're not paying your homeowners association dues. So my first question to you, what's that?
I have been paying my dues ever since I moved in here, except on the rare occasions when I paid them and they've lost them.
Well, I'm not sure we get to $1,269.50 on lost homeowners dues. Ms. Behrens, approximately how many times has he not paid his dues?
I don't know that he hasn't. He has other charges on there for things
Because
that
you
he
didn't send it to court, right?
Right.
So I don't know what you're looking at, ma'am.
I'm looking at his statement.
Yeah, it would have been a really good idea to send the statement in as your proof, because now's the day we're here in court and you're just telling me he owes this money. I have nothing. And he's telling me, no, I pay my dues except for when they lost them. What are the homeowners association dues?
$80 a month.
Every
month.
So approximately how many months has he not paid?
Like I said, I don't know that he has not paid. I'd have to look it through, but he has other charges on there. And I've never
Like
had to
what,
send
ma'am?
it. Like I said, he didn't take care of his yard and so on. So we
Okay, so you have penalty charge. I just assumed it was not paying homeowners dues. That's the
No.
most common variety.
Right.
So why don't you spell out of the $1,269.50? Tell me what it is he owes for.
Well, there's the $675. That must have been for cleanup. We actually cut a tree down, but it was only part on his, so we paid for that. That was $2,000. And he is.
Ma'am, I don't need you to tell me things I don't need to know.
Okay, sorry.
You didn't send in the evidence. I just need you to tell me, what is it that he owes for?
Well, that's the $675, and he's
And
being.
what is that charge for, ma'am? And when is it from?
It's from October of 24.
Okay, and what is it for?
It's for cleanup of his yard.
So you actually paid a third-party service to go in and clean it up?
Yes,
Is that in your homeowners association bylaws?
yes, we go through and
And
do.
what triggers your ability to do that to him?
We have stated, we give them notices, we're going to go through for yard checks once a year. And we go through yard checks, we have a list, and what isn't taken care of, we give them a list. And they have 15 days to take care of it or contact us, and that hasn't been done.
All right, and so you contacted or notified him that
Right.
his yard was on this list.
Right.
And then he did nothing for 15 days.
Right.
And then you hired a third party to come in and clean it up.
Right.
All right, that's 675, what else?
Okay, and the painting of his shed and so on, we aren't gonna do that. So he gets $50 a month charge for that. And then there's.
And that's spelled out in your bylaws that if you don't paint your shed, it costs $50 a month.
Yep, it has to be taken care of, yep.
And then that has not been paid since when? Or not been painted since when? When did you inform him that that was gonna start accumulating a $50 a month charge?
That was last summer when we went through the yard check. Before we did the.
Okay, so how much does he owe for not painting the shed?
It's $50 a month.
Ma'am, you cannot just keep saying that.
for that.
I'm not gonna sit here and add up the months for
Oh.
you. Tell
Well,
me
I
how
didn't-
many months
Okay,
that you are charging him for not painting the shed, that you get to a number.
okay. We've never had to do it this way, but I would do it. Okay. 1,
Ma'am, you've only ever sued one person,
350.
one other time in front of me, and that was for dues. So don't tell me you've never had to do it this way.
Okay, it's $350.
All right, so that's $350.
That's through February.
That's $1,025, so keep going.
And then there's the interest. And that's all like dollar something every month. And that's been going on.
What is your percent interest that you charge?
It's 5.5%.
Okay, that's reasonable. So how much do you have in interest?
I'm sorry, I didn't know I had to add that all up.
Well, ma'am, what did you think was gonna happen? That we just go by the total number?
Yep.
And
I
that
guess
he
so.
doesn't contest it item by item?
This
That doesn't
first
make a
time I-
lot of sense to you, does it?
I don't have an answer for that.
Yes, ma'am. Do you know why you don't have an answer to that?
Because I wasn't told I had to do that.
No, ma'am, because 5% interest to get to $255 on 1,000, that is not 5% interest, ma'am.
It
That's
goes
a lot
back.
more than 5% interest. Your math is bad.
Okay, there's also charges back in 22 and 21. It goes back. There's $50 charges way back. If you need me to, I'll send you the statement and
Are you gonna send it to me in the next 30 seconds? This is the time and place for you suing him. When did you think was a good time to send the information to me so that I could look at what you're suing him over?
well,
How did you think this was gonna work in your head? I'm just curious. That you'd
I
come here
guess
and then
I'm-
I would just say you must win because you're the plaintiff?
no, I'm sorry. I'm ignorant on that part. I've never done this part before, so I'm sorry. I don't know what else to tell you.
Mr. Tibbetts? So here's the
Yes.
problem. If you choose to buy property where there's homeowners association, they can make bylaws, and then you have to live by those bylaws. You may not like them, but as long as it's spelled out in bylaws that if you don't clean your yard up, they're gonna charge you to have somebody come in and do it, you're gonna have to pay that money. Same with if they decide your shed's not painted right.
Yeah, I'm wondering, one, I didn't know that it was $50 a month on the shed bit, and how do you paint over the winter time? But
It was
since-
in the
since
summer we
it-
did that.
well, you said it over February. Also, since April 29th,
Wait,
I've
Mr.
been
Tibbetts, this is
disabled.
important. Are you telling me you were never made aware that you were supposed to take care of the shed and that you were gonna get charged $50 a month?
I knew I was supposed to take care of the shed, but since the end of April of last year, I've been disabled. I've had a serious fall and fractured my spine. It was not able to do a lot of stuff because I was walking with a cane and bending down. I'd have been picking myself up off
All
the
right,
ground.
now, sir, that may very well explain why you didn't do it, but it's not a legal reason why you don't have to do it. You understand?
Yes, I do.
Okay.
One of the board members lived right next door to me, and she knew that I had had the serious fall and was not able to do stuff.
So
And like
here's
I
my
say,
question. Do you
I would
believe
have
that
done
you owe
it
the
if I could have.
Do you believe you owe the
That's-
homeowners association money?
I owe them some money, but not that much. That's six
Okay,
hundred
what
and
do you think you owe the
$75.
money for?
You know what that cleanup of the yard is? For $675, they had a person come around with a gas powered hedge trimmer and cut down everything around the within a couple feet of the house foundation. And they spent less than an hour at it. They picked it up
And
and
sir,
left.
if you had paid someone to do it, maybe you could have had it done for $50, but you chose not to take
If
care of
I'd had
it. You forced
with-
them
with
to
the
take
fact-
care of it, and
fact-
$675 is what they got charged.
With the fact that I was disabled, I was not getting any income. I
Okay,
received.
sir, again, that
With
is
her
a
TV
good
social-
reason why you're not taking care of these things. But for me, it's not a legal reason for them not to be able to charge you.
And also the statements they send me, all it has on there is a invoice number and an amount. I've been trying since back and first started to get them to explain what the stuff is for. That $50, whatever, back then, I've been trying to get them to explain what it's for. And all they
Are
ever
you
send
telling me
me,
you've never had
is
a
this-
conversation with Miss Behrens about this?
no, I haven't. I've sent things through dropping notes that they have a drop box down at by the mailboxes. I
And
put
okay, were you ever
stuff in there.
contacted by them to
When
have them explain it?
no, all they've
All
ever
right,
sent me
then
is a
hold on a
paper
second.
with an invoice number and an
Miss-
amount, and they won't tell me what the invoice is
Then hold on a
for.
second. Miss Behrens, if one of the people in the homeowners association were to go to the Dropbox and say, hey, I'd like an explanation before I pay this, what do you do about that?
I would talk to them, but I've been going to the Dropbox, actually taking care of the treasurer's job too, since May, and there's been no note. But the invoices that are sent to him, I have a copy of the one from February 11. It's $50. It says fine for shed needing painting, and he still had weeds around the shed, growing on the shed.
All right, so the invoices do have some sort of
They
explanation
do.
on them.
It does.
All right.
It's on there. Every month.
All right. Here's the thing, and like I said, there may be some old charges on there, but you're not quite articulating them. I have $1,076.25 worth of stuff that you've articulated for me that makes sense. The yard cleanup, 5% interest, 5.5% interest, and $50 a month for $350 worth of, hey, you got to take care of the shed and you didn't. Would you like to add anything else to there? Because that's about $200 shy of what you asked for.
Well, he's gonna be charged another $100 and some this month, but that's fine.
All right.
We'll just bill him.
So I would make a finding here in damages in the amount of $1,076.25. Mr. Tibbetts, I also need to explain to you that the condominium association paid certain monies out of pocket to get here today. They paid a filing fee to court and they paid to have you served. That was $121.15. They are also able to recover that. So I just wanted you to understand where that extra money comes from. Now, here's what I need you both to understand. Either one of you could say, I disagree with what just happened there. I want to appeal this verdict and go in front of the district court judges for general civil. To do that, you must do two things. One is you must ask for that within 7 days of today's date. Your opportunity to contest this further ends after 7 days. And two, you must come in and do that in writing. You can't just ask for it over the phone. So I just ask you one at a time. Do you both understand your rights on appeal?
Yeah.
Mr.
Yes.
Tibbetts? All right.
Yes.
So we're all set for what we need to do here today. I'm going to release parties. Ms. Behrens, I am going to talk to you just for a second because I'm assuming that the other message I got on the Candlelight Manor case, you're also involved with.
Yes.
I think it was the person you sued last time.
Oh,
The problem is the court does not do collections. So I know that you guys had some arrangement worked out and you're saying he's not doing it and he said they're not letting me do it. But just so you know, the court does not do collections. We would not involve ourselves in whether or not the judgment is satisfied. You have a judgment against them.
right.
You can file paperwork to do things like seize tax returns or garnish paychecks. But you can't just write a letter to the court saying, hey, he's not paying, make him pay it. That's not a thing, okay?
Okay. I was told that by when I called the court, so that's fine.
But there are other things you can file that have a little more teeth as far as like trying to get that money. But just to let you know, in general, the court doesn't go near collections. Once we make a ruling, a judgment, that means they owe you the money, but we do not enforce them paying you. Does that make sense?
Okay.
All right.
All right.
I'm gonna
then,
go ahead and release you. Thank you.
Now, on this one, on Tibbetts, I can say I don't agree with it. I have to send something in. How do I do that? Because that's over $400.
You'd have to come in and fill out the paperwork to
Okay.
appeal to the general civil, and you got to do that within 7 days.
Okay,
And then you would start all over again in front of the district court judges.
all right.
Thank you.